Hi, everyone. Welcome tonight to week 8 of Step Up into Life After High School. We're speaking about guardianship tonight. Again, we have Lee Ray, our Director of Advocacy with the Arc Arapahoe Douglas, on with us. And Lee, I'll let you take it away.
Hey, thanks, Luke. Welcome, everyone. So as Luke said, I'm Lee Ray. I'm an advocate with the Arc Arapahoe and Douglas counties. This is the second of 2 sessions I'm sitting in with you guys on, both focusing on supported decision making. Last week, we focused mostly on ways for you to be recognized as a support for your loved one in making decisions. This week, we're going to, as Luke said, mainly concentrate on legal guardianship. This slide, well, I'll warn you, for those of you who were here last week, we'll have some repetition. Apologize for that, but you've got to cover it all. So this slide is one of those repetition ones. These are some of my background. As we go along, if you have questions, feel free to use the chat. Feel free to chime in. We'll tackle them both ways. And let's get going. So this is the quote I love from the Olmsted decision, because it tells us, talks about the thing that we risk when we are well-meaning, but not necessarily thinking all of the ramifications through. So I think it's a good thing for us to keep in mind when we're talking about supported decision-making, period, and guardianship perhaps in particular. This is, like I said, what we want to make sure we don't do. So I'll go quickly over the disclosures that I also shared last time. I'm not a lawyer. That's the focus of this slide. We're not giving legal advice. We're trying to share some of our experience with you guys, but we'd encourage you to look for legal counsel for really questions and or problems encountered in this process, especially if you're not able to get an answer you're sure of. Secondly, the gist of this next disclaimer, if we get it, there we go. This one is kind of that this presentation can't address everyone's needs. Every individual is an individual and has different needs, different abilities. So, bear in mind that, and some of what we talk about may not seem to apply to your situation or your family member, but it might at some point, and hopefully it's all useful information. And that last point, just as always, if you do have a question that you're thinking is probably too really specific to your situation, Luke and I are both always available to reach out to and have that as a separate conversation. And my third disclaimer slide is where I'm coming from. So as an advocate and as a friend and as a person who's dedicated their lives to this stuff, I value self-determination by people with IDD. I value safeguarding their rights, their basic human rights, person-centered planning and person-directed services, the least restrictive level of support that will work for in any situation, and the idea of dignity of risk, which is basically having enough rope that you don't hang yourself, but you've got some free movement there. that we learn from our mistakes. And that's something that sometimes when we get overprotective, we don't allow our loved ones to do. So that's the disclaimers. This next one is, oh, sorry, I forgot my big powerful slide. Because of those values, we are at the Arc of Arapahoe and Douglas, including myself, we believe guardianship, legal guardianship, should always be a last resort. Again, we talked quite a bit about last week about other options, and I'll touch on that a little bit as well this time around, but that's the perspective that I'm coming from. So this one is a quick overview of what we're going to talk about today. We are going to talk about deciding if guardianship's the appropriate path to take. We're going to talk a little bit more about supported decision-making, both that there are alternatives to guardianship and sort of how it works within guardianship. We'll talk some about the process, not a ton, but we'll give you a place to find the forms that are necessary for doing it. We'll talk about types of guardianship. We'll talk about who's going to succeed you as guardian, those sorts of things. We'll talk about a little bit of what guardians do and don't do, what liabilities they assume and don't assume, and the things that guardians are not given the legal ability to do. So let's start off with a little myth busting. So look at these questions, and anybody who wants to chime out with it, and well, they're not questions, scenarios, thoughts, with an opinion on them. Guardianship's automatic for the parent of a child with IDD when they turn 18. We think that's accurate?
No.
It's not. 18, what's automatic for a person with an intellectual developmental disability is the same thing that's automatic for all of us. They become their own decision makers. The only way to change that is through a court action. So now the second one, if I'm my son or daughter's guardian, they won't be able to date someone I believe is not a good match for them. Any thoughts? This is also a no. One of the things that guardianship does not give the guardian is the ability, both in a practical sense, but also in the law, to control a person's relationships. You can't, they want to dye their hair, you're not going to have a whole lot of control over that. They want to have sex, you're not going to have a whole lot of control over that. So guardianship, there are very real limits, many more than just what's limited in the law, that are just practical limits. So if my son or daughter, if I'm their guardian, and they do something illegal, law enforcement won't talk to them without my permission and would call me immediately. What do you guys think?
Probably true.
Unfortunately, it's not. It's a no. For one thing, it's a different standard, legal standard. Once they figure out that there may be a intellectual disability, they might do some reaching out, but guardianship does nothing to protect your family member from the criminal justice system. So if they do something illegal, law enforcement will arrest them, they'll interview them without you being present. Eventually, hopefully, they will reach out and get a hold of you. But
because in the other moment is Lee, it's not like your son or daughter walks around with a sign saying I have a guardian. It's not necessarily in the police database. It's not something that's transferred that way. So it wouldn't be until you either are notified or someone notifies them that, oh, they have a guardian, that they would finally reach out to you.
Mm-hmm. Absolutely. And being their guardian does not, the fact that a court has assigned them a guardian, as it were, does not change their responsibility for following the law, does not protect them from being charged, etc. That's a different legal standard. Service providers will have to listen to me and follow through on my wishes when it comes to things like a healthy diet. Another way you hear this is they don't have to listen to you if you aren't guardian. What do people think? We actually talked about several different roles that you can take last week that are legally recognized by the system and will ensure your participation in decision making and supporting your loved one with decisions. You know, I'm an advocate, and I act as guardian for a few people, but I do not. I am not guardian for the vast majority of people that I advocate for, but generally speaking, they listen to me. You know, so that's not the leverage that you'll often hear from schools, from other parents, from wherever, that, oh, you need to have guardianship in order to have a voice. That's not really true. All right, so, and then the last one, every person over the age of 18 with an intellectual and/or developmental disability needs a guardian. Now, I would definitely argue that the vast majority of individuals with IDD do not need a guardian. Just like the rest of us, all of them need support in making decisions. And the level of support needed varies from individual to individual. But here's another quote I threw at you last week, but I again, like it. So, typical ward has fewer rights than a typical convicted felon. It is, in one short sentence, the most punitive civil penalty that can be levied against an American citizen. Now, none of us, you know, this is a powerful and sobering statement, but obviously none of us go into the idea of considering guardianship because we want the most punitive civil penalty for our loved ones. But again, like that Olmstead statement, it's the flip side of the coin, and we need to consider the other impacts that this can result in. It can result in your loved one no longer having the basic legal rights that even a convicted felon has. I wanted to go back to a example I shared a little bit with, excuse me, with you guys last week. A woman I've done advocacy for a while who she's still in her mid-20s. She's accomplished a lot, jobs. She has her own condo. She's very outspoken of what she wants and really capable in a whole lot of ways. She, however, has problems with executive functioning. She can't anticipate the consequences of her actions a lot of times. So her parents pursued guardianship at 18, partly because, and conservatorship, partly because she was inheriting some money, but also because of their concerns about her making prudent decisions. And they love her dearly. Many of the decisions and things that they have done have benefited her. But what they didn't anticipate is she now struggles with depression. She's repeatedly quit jobs and gave up on goals. She's isolated from friends and family. She was in an abusive relationship and stayed in it. She resents her parents for the guardianship. And, you know, they saw all of that, or most of that at least, as further evidence of her not being able to make prudent decisions and her need for a guardian. She, again, resented them all the more for that. Now, clearly, all of the issues that she deals with aren't because of guardianship, but in her mind, virtually everything gets blamed on guardianship, on the fact that she has a guardian. And I guess the other point is the guardianship played a role in their supporting her in the abusive relationship, but they couldn't prevent that relationship. It's one of those in a practical sense, guardianship doesn't give you this power issues. So, supported decision-making. You know, again, we talked last time about what it is and some options for establishing that you are the individual who supports your loved one in making their decisions, legally recognized ways of doing that. Supported decision-making is empowering. And as I said before, something we all do. When we need a specialist or when we need an opinion, something we all do. Guardianship. So again, kind of going back to why I see it as a last option. It's the removal of rights. It's usually the complete removal of legal rights. They no longer have the ability to make any decisions. There are some people who need that kind of support, that level of support, but most don't. Most just need support with the decisions they need to make. Jonathan Martinez from the National Center for Supported Decision Making describes that as an alternative to guardianship, a way of helping individuals make decisions, the choices they face, so they don't need a guardian. We're not at the Arc Arapahoe and Douglas anti-guardian. Having said all of this, and I do see it as a last resort, I again act as guardian for the Arc for a number of individuals. And those are situations where the individual needs that level of support. That they generally fall into two broad categories. Some of them have, the majority of them have no effective communication. They have no or very limited speech. They are not able to use augmentative communication devices. They may be able to indicate their preference through sight gaze or reaching or pointing for very simple choices, but they don't have any effective way of communicating what they would decide. There are a few other folks that we act as guardian for that we took over. We became successor guardians for family members who had become guardians, who, you know, we may not have pursued guardianship if it was up to us, but that points out one of the things that's true about guardianship. It's really, really, really difficult to reverse.
And so on that, that's a great point, is it is a very difficult, almost, impossible to reverse. Once you've established yourself as guardian, you're going back to a court saying 2, 3, 10 years ago, this individual, because of their disability, wasn't able to make informed decisions. So we need to strip them of some of their rights, or a lot of their rights, in the terms of guardianship. And now we're going to go back and say, but now they can make those decisions. So it's very hard for a judge to overrule another judge in that decision making of who is competent and not to be their own guardian, but also the level of you have to show for that they are able to now make decisions that they couldn't make 5, 10, 15 years ago is a big decision. So that's where the arcs come from with guardianship. Is it's not we're anti-guardian at all. We just really want everyone to take a look at it in the eyes of this is a one-way ticket. You're not really going backwards with your loved one and releasing guardian. So they're going to have a guardian for the rest of their life, pretty much. And we do promote guardianship to individuals and families when it's the resort they need, and so families that are in a, divorced and one parent is legally not allowed to be around the child, at 18, the parent that has the child will need to go seek guardianship right away because that court decision of, that the other parent can't be there goes away. Or if you're an adopted parent, so you've adopted your granddaughter, grandson, or just an individual on your own, at 18, that court order that removed that loved one from the previous parent goes away. So you might want to step in and take guardianship to protect them. So in situations to protect an individual, guardianship at 18 works really well. For most of the time, we tell families, let's wait and see. Like, let's start with the slow steps, supported decision making, HIPAA releases, power of attorney things. So we can they can still have all their rights and all their powers before we go to the line of guardianship. We might take us years before we ever recommend guardianship to a family, or it might be at age 18. So it just depends on your own family's needs.
Right, and the circumstances. There may be, criminal justice involvement that is important or are complicated enough that they need a legal voice. So there are absolutely situations where guardianship makes sense. As Luke pointed out, there are other situations where it may eventually be what works, but if it's possible there's no time limit. So if it's possible to try other options, we encourage that. So how to decide? We talked about this as the way to break up some of the other formal supported decision-making positions last week, but in some ways it's a good starting point around guardianship. Not only what are the decisions that you're worried about they're being able to make, but what level of support do they need to make those decisions? Is there, your knowledge of them and your ability to break thoughts down into a communication style that works for them? Is that the main part of it? Is it information? All of those sorts of things. Are there specific pieces that that it makes sense to have decision-making power? Is there financial resources that need to be managed? Are there medical things that are complicated? And as we talked last time, we can do a lot with power of attorneys and those sorts of things. I'm gonna do a quick read the definition from the law real quickly of how the law defines an incapacitated person. So this is a guardianship law, and it's specific to who. No, I'm varying off my slides there, Luke. You haven't fallen behind. Sorry, I just wanted to stick this back in. Oh, it is on there. Oh, I'm sorry. All right. Individual other than a minor who is unable to effectively receive or evaluate information, or both, or make or communicate decisions to such an extent that the individual lacks the ability to satisfy essential requirements for physical health, safety, or self-care, even with appropriate and reasonably available technological assistance. So it's fairly complicated language, and if you think about it, it's quite open to interpretation. The person I was describing for you, in her case, her parents' lawyer had felt very strongly that she fit into that definition easily. And I felt just as strongly, no, she can communicate. She may not make the decisions you want, but she can communicate them. She can make choices, all of those things. So it's wide open to interpretation almost. So the process in best practice is interested parties, family, professionals, whoever, discussing it, talking about, is it in this person's best interest to pursue guardianship? Will these other options work? Have these other options worked if we're further down the road? Best practice also is to kind of document those conversations and why guardianship is needed. It's a good process for you to go through thinking about it and thinking about the alternatives. But it's also basically part of what you're going to put in the petition for when you file for guardianship, if that's the decision that makes the most sense. Other considerations about guardianship, it is a court proceeding. It's a long process. There are costs and there are ongoing annual reporting. The biggest is it takes away the basic civil right to make their own decisions. This is a question that often comes up. You can't file until the person is 18, but can be filed at any time after that. So there's no time limit. As we said, it's very difficult to reverse. And one other thought kind of on that subject, it's particularly difficult. It's difficult in every situation, but when the original guardianship is granted because a person has an intellectual developmental disability, to prove that IDD is not something we graduate from, to prove that the person has gained the skill to now make decisions when a court said it hadn't been there before is a higher barrier. If the reasons were mental health issues, there's concrete things you can show to say, okay, the mental health is under control, this person can make more decisions. So, and one other consideration that's critical is who succeeds you. I mean, in the case of parents, we certainly all want to outlive our children. And if guardianship doesn't go away, there's going to have to be somebody taking over for you. If you don't have that plan, that's something you really have to put thought into. And it may even be a point where guardianship doesn't make sense because there isn't someone who can step in. All right, so let's talk a little bit more about process. We're not going to go into a ton of detail on this, but it's well explained on the website that I'll show you in a second. And there's a guardian manual that tells you a lot about guardianship. We are always available to help with this process, and you can absolutely get legal counsel to help with the process. But so basically, you file a petition with the district court in the county where the individual lives. You're going to have to file background and credit checks to go along with that. There's paperwork that there's several things, acknowledgement of responsibilities, and notices about hearings, notices about the petition, those sorts of things. You're going to complete that paperwork, and you're responsible for sending those things out to the people who need to have notice. Generally, you want to include a letter or a report from a doctor or a professional documenting the need. And going back to that discussion we talked about, that documentation certainly helps. There are fees associated. There is the ability to request a waiver because of need. Once all of this is in place with the court, then the court assigns what's called a court visitor. That person interviews everyone involved to the degree that the people can respond. And they write a report for the court. The petition, the information you've put on the petition and attached to support it, and that visitor report is what the judge or magistrate is going to use to make the decision. Most of the ones I've had experience with want to meet the individual as well, want to see them in court, but mainly their decision will be based on the interview questions, those sorts of things from the court visitor report and what information you've shared with them. Delivering the notice of hearing, of those sorts of things. If and when there's an appointment from the hearing date, you've got to send notices to everybody from that. And then there's the guardian report. You file the first one generally about 90 days from when guardianship is put into place, and every year after that. So here's where you find the forms. This navigation is, I think, still pretty accurate. They changed the forms, especially the guardianship report. Seems like yearly, and they changed the layout of the web page quite often too. But it's easy to navigate. It's and like I said, there's a document that's kind of instructions for, and there's a guardian's manual. So there's good information there. Colorado Bar Association has, they have links to their pamphlets and documentation about guardianship and conservatorship. So all useful information. Now, process, what I think, Luke, you and I are on a different timetable here. The two questions, or the two, court makes two, decides two questions slide. Nope. Back. Sorry about this. We did some editing of the program, and chances are I set up my talk based on the old slideshow. Go back one more, or two more rather. Okay, so what the court does is a two-step process. Basically, they're making, based on that incapacitated definition, the court's determining that the person is incapacitated. Secondly, the court is deciding whether the petitioner should be appointed as guardian. So it's a decision, you're documenting both the need for a guardian, why the individual can't make their own decisions with support, and you're documenting who's the petitioner is documenting why they should be the ones granted that guardianship. Thank you. So let's talk about kinds of guardianship. Plenary guardianship or full guardianship. Jonathan Martinez, again, my favorite guy, talks a lot about it's used all over, that's full guardianship is what's used. As long as the law permits plenary guardianship, courts will prefer to use it. A concrete example of that is 20 years ago, before the guardianship law in Colorado was changed in 2000, 2005, and then one more time since then. I can't remember what year, but maybe 2015. The 2000 change took away documentation specific to limited guardianship. Colorado doesn't even give you documents that you can use to limit guardianship. You have to know that that's something you can do, and you have to write it in on the letters that you're filing with the court, or it will be automatic, de facto full guardianship, taking away all legal rights to make decisions. Now, limited, you can limit it somewhat similar to what we talked about last week about power of attorneys. You can put limits on guardianship that are specific to the individual and make sense. You may want to have a guardianship that is only that you make medical decisions and financial decisions where the person lives. Everything else is up to the person, or one or two of those. But it has to be specific language that limits the extent of the guardianship that, again, you have put on the forms that you're filing with the court. There's no checkbox place where you can say, I want to limit. All right, so then the successor question, going back to that a little bit. There's co-guardianship, and there's actually documentation at that website for designated successor guardians. Prior to that 2000 guardianship law change, all you had to do is put it in your will who you wanted to take over for you. That didn't make a whole, you also didn't have to file reports back then and all sorts of things. So there's real positives to the courts saying, wait, we need to do better oversight of this process to make sure it's not being abused. Often I will advise people to consider adding a co-guardian from a younger generation, for example, prior to the need for a successor. It can make that transition during what can be a pretty tough time if it's, parents have guardianship and they pass away, or they're suddenly needing really intensive supports themselves, to then have to go to court and file a petition to become guardian. Even though there's indication with the court that you want them to be successor, you still have to go through all of that. And so picking the time that you do that can be helpful. And the way of doing that is to name somebody as a co-guardian. Obviously, mom and dad can be co-guardians as well. It doesn't have to be intergenerational, but it's a way, co-guardianship is a way to look at that successor question. Basically, if you have co-guardians, they should be in basic agreement with each other on kind of the larger goals, as it were. There is no really implied priority unless you write it in as priority on the things that you're, on the letters and the order appointing. If there's a legal challenge, the court could order priority. That's pretty rare, but, and then in most cases, again, unless ordered by the court, having co-guardians doesn't mean everybody has to sign everything and everybody has to be, it means that each guardian has the legal ability to do those things. So I did have one circumstance with a family where parents were guardian, they wanted to add brother and sister. So it was going to be 4 co-guardians. And the judge actually said, 4 co-guardians, how are you guys always going to agree on things? And questioned and I was in court with them. So I said, Your Honor, I was the one suggesting they do this because parents are out of state a lot, and because as they age, they want to make sure that brother and sister can step in. But you could have that question of, wait, do you have too many chefs? Now we'll go back to supported decision making. I have forgotten to pause as I'm talking and ask if there are questions. So again, anybody with questions, jump in. At the end, we'll have a period of time and we can certainly go back on things. But so the last rewrite of guardianship law in Colorado added this language, or built on the previous language that wasn't as strong, that really defines supported decision making and makes it something the guardian should be doing, only exercising authority as necessitated by the word's limitations, and to the extent possible shall encourage the person subject to the guardianship. I am not a fan of the word ward, so I generally leave it out, but this is their wording. Shall encourage them to participate in decisions, act on, and you will act on their own behalf. A guardian in making decisions needs to consider the desires and values of the individual. Always act in that person's best interest and exercise reasonable care, diligence, and prudence. Last week we talked about that prudent man rule that is specific in conservatorship. There's not there's no more specific language than what you just saw in guardianship law. There is less basic liability, and we'll get to that as we go through these next few slides, what a guardian does and doesn't do. So things that a guardian is expected to do. Is everybody seeing the next and previous box, that, or am I only seeing it? There you go, thank you. Didn't want to block some of the text from folks. So, you need to stay knowledgeable about the living situation. You need to see them as often as possible. In the days of COVID, that some of the folks I act as guardian for, I haven't actually seen face to face for quite some time, which kind of breaks my heart. But I do Zoom calls with them. I do whatever we can. So the court wants to see, and you document in that yearly report how often you're seeing them, how often you're contacting the people who support them. Planning for the future. The guardian has the ultimate decision on where an individual should live, unless there's a court order of some sort that trumps that. But generally, you will be deciding where they live. Again, supported decision making, so their input is important, obviously. Make decisions about care, health supports, daily needs. You have to give the court notice when either you as guardian, technically, either you as guardian or the individual is traveling out of state or out of the country. I'm not sure how they check up on that, but that's part of the expected responsibility. A guardian, I think Luke's nodded off there for us. Usually it's him picking on me, so I had to get that jab in. The guardian also, as we talked about when we talked about the financial stuff, there's a conservatorship when there's large amounts of money, there's other options. But in general, with someone who has limited assets and really only has income sufficient for their sort of day-to-day needs, the guardian may be managing those finances, and especially if that person doesn't have a rep payee through Social Security's, the guardian may be managing those finances. And if that's the case, then that's part of your reporting to the court on a yearly basis. The only liability really that a guardian assumes is negligence on their own part. So your own actions in regards to neglect or exploitation of the individual subject to guardianship, that's the only assumed liability a guardian takes on. You do not, a guardian can't decide I'm going to use their SSI to, pay for my vacation or whatever. That would be liability, but otherwise, changes in residence, death, the court needs to approve a person's moving out of state. Generally, that's really just the court wants to know they're moving out of state and give a heads up to the state they're moving to that Colorado has put guardianship in place. Guardianship law is a state law, so it varies state to state. And if you were to move to another state, you would have to notify Colorado and then go through the process with the state you moved to of getting the guardianship recognized there. As I said, there's the report 60 days after appointment and yearly thereafter, where you detail health, social situation, financial situation, the supports that are in place, their ability to help make decisions, how often you see them, how often you can connect with their support system, lots of questions like that. It's gotten more and more detailed as the years have gone on. All right, a guardian does not, these are those, what I was saying, you assume your liability for your own negligence, but you do not assume financial responsibility for the person subject to guardianship. You do not have to pay for things that they damage. You do not have to pay for medical bills they accrue. I've had hospitals come after us trying to get money, and for medical bills that, a person who's just getting $700 of SSI a month and that's their only income can't afford to pay off. And I've sent the hospital the copy of guardianship law that says guardians can't be held financially responsible. You do not have to provide a place for the individual to live. We talked about you do make decisions around that, but you don't have to provide it. You do not assume a liability for their actions or behaviors. They, as we said with our myth busting, still have liability around their actions if those actions cross the line into criminal, even though they may not understand that. And so there's that piece, but nobody can come after you for that as the guardian. Guardian also does not assume liability for harm to the individual that is caused by a caregiver chosen by the guardian. So that's one of those limits on, or a clearer definition of what they mean by neglect on your part. It's not neglectful on your part that you in good faith chose a caregiver who then caused some harm to the individual, stole their money or whatever. Alrighty. Then there are a few things that are very specifically stated in the law that a guardian cannot do. A guardian cannot admit the person into an involuntary mental health treatment facility or a IDD regional center, those sorts of placements. That's not the guardian's decision. Those are typically, when you go beyond a 72-hour hold kind of a situation, that typically becomes a court process. A guardian cannot order sterilization of the individual. And as we said earlier, can't prevent incarceration of the individual and can't limit their associations with others. So that is the quick and dirty on guardianship. So I want to open it up to you guys. Questions, thoughts?
One moment. So that'll end the guardianship discussion for the video portion of this. So thank you so much.